I'm Colin O'Keefe, and this is LXBN TV. As seems to happen frequently, the NLRB has been causing quite a stir across the LexBlog network, this time for two reasons. As a previous impactful board ruling on arbitration agreements was overturned, and the board agreeing to dismiss its own appeal of a court ruling invalidating its ambush elections rule. Joining me now to share his comments on both of these stories is attorney Ronald Meisburg. He is a partner at Proskauer. He is also the former general counsel of the NLRB, and he is author on the firm's blog, Labor Relations Update. Ronald, you wrote on both of these issues, but let's start with the board's D.R. Horton ruling. Can you explain the impact here where the board's ruling on arbitration agreements was struck down?
Well, it's certainly good news for employers from the standpoint of previewing how the courts are going to be looking, hopefully, at the board's D.R. Horton ruling, which had basically said you could not have an arbitration program that didn't include some kind of class action component, either for court or at arbitration. But as a practical matter, the board will probably continue to follow its decision in D.R. Horton. The general counsel will probably continue to issue complaints as he has in the D.R. Horton issue. And so for the foreseeable future, these will still be litigated before board administrative law judges and the board, and then they'll go into federal court, and then we'll see what other courts besides the Fifth Circuit have to say. There are about 5 or 6 of these cases currently, I understand, at the board. So I think we should be seeing some of those come out within the next few months.
I see. And then the second story, like the first, seems impactful, but we do need to see how this develops. But I will let you explain that. So what are your thoughts on the NLRB withdrawing its appeal of the ambush election ruling? What's the impact here?
Well, that's an interesting thing because the board had actually issued these regulations in 2011, and the regulations had been challenged in the United States District Court in D.C. The district court judge had basically vacated them because he said not enough of the board members participated in not a quorum participated in their promulgation. The board appealed that to the D.C. Circuit, and when it got there, the Noel Canning issue, the issue of whether or not Member Becker, one of the other members of the board that promulgated these regulations, whether he had been legally appointed. So now you have a real train wreck, frankly, at the D.C. Circuit, and the board has expressed, a number of members of the board, particularly the chairman, have expressed an interest in completing their promulgation of these election regulations. But in order to do that, they really needed to get this first group, the litigation had to get resolved. And since it wasn't going to get resolved until the Supreme Court rules in the Noel Canning matter sometime in late spring, I believe the board basically said, look, the best thing to do is let's just withdraw our appeal and go back and start again with respect to all these election rules and start afresh. Now, what that means, or whether that means they are going to take comments again, or whether they're going to treat the first record as applicable to some of the regulations they want to propose, we'll just have to see. It's not clear what they're going to do next.
I see. It's going to be interesting to see what the next steps are. Again, both seem impactful now, but we do need to wait to see the full ramifications. Once again, that was attorney Ronald Meisburg of Proskauer. For more of his insight, be sure to visit laborrelationsupdate.com. And if you're not watching on our site here on LXBN, be sure to visit LXBN.com, where you can find curated commentary from the LexBlog Network's more than 8,000 members, in addition to hundreds more of these LXBN TV video interviews. Thank you for joining me today, Ronald.
Happy to do so, and happy holidays to everyone.